Melissa Isaak is on Zoom.
Yes, sir. Thank you for this opportunity. I'm cognizant of the time constraints and try to stay well within that. My name is Melissa Isaak. I'm a licensed attorney. I'm a former child therapist, and I'm a member of the JAG Corps in the Army National Guard. I also went through family court as a child and was a foster child, but my testimony today will focus on my experience with the system as a professional. I've practiced domestic relations law with a strong focus on shared parenting. A large part of my practice is child custody cases where the best interest of the child standard is utilized. One of the biggest problems with utilization of this standard is that in practice, there's a presupposition that the child's welfare is promoted by one parent having more time than the other parent, sometimes considerably more time. Based upon the research that is now widely available, we know without a doubt that's not what's best for children. But the bill is asking to impose a rebuttable presumption that shared custody, as equal as possible, will be the starting point in custody cases, and that parental fitness will be taken into account before relegating one parent or to the status of a visitor or given more time than the other parent. If a parent is found to be unfit, if a parent is not found to be unfit, if they're found to be fit, there's really no constitutional basis for stripping them of meaningful time with their children. And this constitutional basis is important because it's already the law. Now, earlier, there was a talk about the Troxel v. Granville case, and that was in 2000. That's where the Supreme Court of the United States held that the interest of parents in the care, custody, and control of their children is perhaps the oldest of the fundamental liberty interests recognized by the court. It's a 14th Amendment interest. That parents have a constitutional right to engage in the day-to-day decision-making to oversee the care and custody and control of their children, and to take away that liberty interest, that right to parent your child, the state should have a compelling interest in which the vast majority of cases that can't be shown. In fact, currently the law allows states to strip a parent of this right without even telling them why. And this flies directly in the face of constitutional rights of every parent who walks in family court. And we talk about the presumption of fitness. Well, there already exists a presumption that parents act in the best interests of their child. Okay, so there's a presumption that fit parents act in their children's best interests. That was a Supreme Court case from 1979. And normally there's no reason for the state to inject itself into the private realm of the family or to really question fit parents' ability to make decisions on behalf of their children. But with the current law, simply the filing of the divorce gives the states the right to come in and say, okay, we're going to question both of your fitness, when really it's the other way around. Parents already have that constitutional presumption that they act in their children's best interest. Right now, it's unfortunate. I think any domestic relations attorney, any honest attorney will tell you that when a client brings in custody paperwork, the first thing you do is you see who the judge is on the case. You see who the case was assigned to. Because right now, the judge's ideology and personal biases versus what the research has defined as what's best interest really dictates the outcomes of your case. And what this bill will do, and again, I'm cognizant of time, what this bill would do was recognize the legal rights of parents that already exist and take away some of the discretion that the judges have. Because again, I think any honest attorney will tell you that we have seen abuses of this discretion and parents losing these fundamental rights with no explanation as to why. And we're seeing the outcomes of children growing up without parents, mainly fatherlessness, and that's the fastest way for children to become statistics. I understand I'm cognizant of the time, and I do appreciate you giving me this time.
Thank you, Ms. Isaak. We appreciate that. Thank you, Ms. Isaak, for your service in the military as a JAG member